Motions are coming in so fast, including ones from Blake Lively. We brought in Ron Zambrano, employment entertainment lawyer to the stars. Let's break it down. Welcome to Popcorn Planet. I am Andy Signore, and I'm so honored. Ron Zambrano is back. I got to first start with congratulations to show how serious our guest is here. I want to point out he just won a suit against Soulja Boy, who has been ordered to pay $4 million to a Jane Doe in this SA case. Congratulations. Bravo. That's not easy to do. Welcome, and how are you feeling after that win?
We're feeling vindicated and exhausted. It was a full 5 weeks of fighting and the other side trying to hide things. But we got there, and the biggest satisfaction is our client, feels heard for the first time. This is a 5-year journey for her. So, there's a lot of satisfaction, a lot of processing, but right now I am just happy to have bandwidth for normal things. But we're really excited, really proud of our work.
It's a long case. We should do another in depth at that point. I mean, it doesn't matter. One, Soulja Boy, not the nicest guy, it seems. And the court agreed. So it's nice to see, as we're seeing so often in cases, that no one believes the victims anymore, it seems. It's good to see the court did believe a victim here. And you feel vindicated.
Yeah, vindicated. Again, this is 12 jurors, 12 people of the cross section in the west side of LA, because we were in Santa Monica, and they heard the evidence. And they believed her side of the story as an assistant, that he abused his power and did terrible things to her. And now he owes her about $4 million, a little over $4 million.
Whew, so thank you for coming again, as always, just so you guys really get an extent of how much Ron is an expert on this material. Because again, It Ends With Us case is all about employment law. And he just won a case with Soulja Boy's assistant proving that he did bad things. I want to get into It Ends With Us, because obviously that's where we've been leaning into, and I know folks are excited to hear your take on this. You had a chance to look over the response. We're going to go through some specifics, but I want to start with one that came in earlier, which was this note from Wayfair's team, Wayfair, Justin's team, basically fed up, writing the judge saying, Your Honor, we have 1,600 requests, 180 interrogatories. We've already gone through 500. We have hundreds more to go. They're refusing to delay a month so we can respond to everything, on top of all of these motions to dismiss and replies and everything. As I look at it as a layman, it looks like Team Blake is just attempting to drown them in paperwork and dismisses, et cetera, et cetera. Is this a lot, and is this obscene of Blake's team to not meet them in the middle and give them this month? What is your take as a lawyer, entertainment lawyer, looking at this?
So you kind of buy into a scorched earth tactic when you take on high-end celebrities like this. Like, it's going to be insane, but even these numbers are absolutely, it's obscene for the amount of stuff they've done. And this is not something that the court really should even be taking a look at. For any attorney to go to the court going, they're not playing fair, they're not being reasonable. This is actually quite a big step, because this is stuff done behind the scenes, just in an email, and people go, yeah, I get it, you can have more time, I understand. And for one team, for Lively's team to be like, no, we think it's fine. I think that this is going to really hinder their ability to look like they're acting in good faith in court when the judge sees this and goes, wait a minute, why are you acting like this? You guys are trying to work together, and you guys are being an obstacle to this being done well. And now I have to step in as a parent. I don't think it's going to be a good look for Lively and her team.
Yeah, it's one of many, it seems, bad looks for Lively that we're getting one after another. It's so bizarre what is happening over there on that side. I can't fully figure it out. Now, I want to go through Blake's response to keep that energy. So going through some of the segments that she's doing, and this is the response to the motion to dismiss response. But I wanted to start with this part here, because she makes it feels very catty in the beginning, which was added last night in the docket. But they start by accusing the Wayfair parties of filing their lawsuit as a PR stunt. And they continue to try to use Baldoni's feminism against him. In this quote, unable to identify any actionable statements by Miss Lively, they argue she is liable for things her husbands allegedly said. In 2025, wives are not responsible for their husband's words. It is incredible that Baldoni, a person who calls himself a feminist, would take such a position. They argue that they're realizing that the loss of defamation claims subjects them to attorney's fees. And so they also mention here that they attacked the defamation claim subjects their attorney's fees, treble damages, blah, blah, blah. They attack the provisions that's unconstitutional on constitutional grounds, which is an attack on all victims of SH and assault. Fortunately, the Wayfair Party's effort to invalidate California's duly enacted legislation is frivolous. The First Amendment empowers legislation to protect victims' First Amendment rights via fee-shifting rules designated to deter retaliatory litigation. So I guess I want to start right there. Would this actually be considered an attack on all victims of SH, or is this dramatic effect that she's playing, in your opinion?
Well, my memory of where this is referenced in Baldoni's paperwork, I think it's a footnote. I think it's something that's in a footnote. He's like, it's kind of like, oh, by the way, this is a matter of first impression. This is a California law in New York. And they have blown that up in order to, as lawyers tend to do, when they are trying to deflect the issue, is like, we're going to spend a lot of time on this thing that they put in a footnote. And when you put something in the footnote, that means if you have time, please read this versus what we're actually saying in the body of the text. And it's really trying to distract, and again, trying to get on this high horse of which a lot of people are not saying she deserves to be on.
Okay, so it's dramatic. There's dramatics here, clearly. I mean, both sides get dramatic, but that feels extra dramatic. She's really playing that victim card really loudly. As we go through all this, there's a theme, I guess I didn't even mention, which we talked about before air. There seems to be a lot of legal gaslighting, to coin it what Kim has said, where they do just feel like they're drowning them in motions and derogatories and everything to sort of stretch it out, cause them more time and money, which clearly they have. But is that a tactic that's common in these types of things? Is that ultimately, you think, what she's doing? She knows maybe, okay, I'm losing, but I'm going to make this as painful and as expensive to them as possible?
Sure. So a very common tactic when someone's feeling they're against the ropes is you start filing things that you want to try to confuse the judge. And yet it's really, these things are actually quite simple, and a good lawyer will simplify it from the beginning. But when you come at something where you are trying to muddy the waters, it's in an effort to confuse the judge, for the judge to make a ruling that is based on a unclear picture that has been intentionally made unclear by the person who feels they're against the rope, because that's their next shot. So when I was reading this, I'm like, wait a minute, this is kind of flipping the script. This is not really what this is about. Legally, this is not where this is. There's a lot of throwing of dusting up the water so that it's not clear. And this has to be fixed during oral argument, because unless you have permission from the court, Baldoni's side cannot file something in response to this in federal court. You need special permission, which I anticipate I would at least ask, like, listen, there's a lot of stuff here that's wrong. I would like, 5 pages to try something, 10 pages to try to clear this up. If not, you have to do your best work on the record in oral argument, which also it can be hard because the judge is just listening to you after reading everything.
My God, the judge has to read so much. I want to go through some more specifics in here, just because Kim,
of course,
my team had questions here. So in addition, the opposition fails to address that many of the defects that require dismissal with prejudice failed to allege specific monetary harm, does not dispute that each claim is rooted in defamation, ignores California, blah, blah, also goes in to sort of say this group pleading of everybody, which to collectively, these claims on behalf of them all collectively is meritless. Is that true? Were they not all defamed by the New York Times and Blake's actions, the Wayfarer group? And do they have to disclose a specific amount in order to claim losses? What are your thoughts on either of those points?
So so to answer your first question, yes, they have a good faith basis as it's pled. I wasn't there and I'm not them and I'm not in their hearts, neither are you. But as it's pled, that is allowed. You're allowed to have a bunch of people saying this conduct came from this other group of people and it was republished and these things that were republished are defamatory. That is quite okay. And you don't have to put a monetary harm in the lawsuit because there is no requirement of that from what we call a pleading standpoint. Pleading standpoint means what you have to put in the complaint just to start it, right? And if it's not good enough, you kick it out. And and there's stuff that's erroneous, you can kick it out. But at this pleading standpoint, you don't really have to put a monetary number. That doesn't make the thing fail. And for her to put that as, not her attorneys, for her attorneys to put that as a first thing of look how terrible this complaint is on a thing that doesn't have to be there, to me falls flat. And I think from a legal writing and persuasive standpoint, the judge is going to see that and go you're going to start there. That's where you want to start. I don't think it's very persuasive.
Okay, another point to bring up about this whole, well, Ryan said this and Leslie Sloan said that. She argues that two of the defamatory statements have nothing to do with her. Ryan's statements against Baldoni as well as Leslie Sloan's, and the third statement is unidentified. So as they go in here, Wayfair parties failed to identify a specific defamatory statement made by Miss Lively and ignored the single publication act. The closest they come to a specific statement is arguing that Miss Lively falsely claimed that the Times or other media that Wayfair had engaged in an insidious PR sabotage operation deployed as revenge for SH complaints, and the two protections for return to production were proof positive that SH was anemic in the film's set. So the question to you, does Blake Lively hold responsibility for these defamatory statements that Ryan or Leslie said? Can that be argued? How would they argue that?
Well, this is really good lawyering. This is gaslighting. So at the end of the day, the complaint of discrimination with the Civil Rights Department, as you remember how this all started, why now Baldoni has his claim, that was signed by Blake Lively. That is her statement, right? It doesn't matter that in her statement she's quoting other people. She's the one that signed it under penalty of perjury. So she is ratifying these statements as part of her claim. And then somehow we all know, and not we all know how, but the New York Times got an advanced copy or advanced knowledge that this was going to happen. So the problem for her is not this isn't a vacuum, and Baldoni found out this person said one thing. She ratified this as having been a support of her own claims that was then repeated by New York Times. So for her to be like, well, that's not really what it means, and you shouldn't attribute that to me. Well, you wanted it to be attributed to you when you first started this. And Friedman, I'm assuming, because so far he's demonstrated he's a very, very, very talented attorney, will point this out, going like, wait a minute, she already signed off on these statements, and now she's saying that's not really her statement. I think it's going to really look bad on her, and especially in oral argument, because I know Friedman's going to do it.
There's another one I want to get your thoughts on, which is the fact that this gloves come off was the threat that they made. Blake's filing reads that in opposition, the Wayfair parties identify two acts they claim support civil extortion. It's all about extortion is what we're talking about next. They cite unknown executives' comments that Miss Lively allegedly demanded an apology from Wayfair and Baldoni, or the gloves would come off, was the quote. They did not explain how this amounts to a wrongful threat. Apparently, Blake does not consider gloves would come off to be a threat. What do you think? Is that considered a threat? Also, Kim, my producer, noticed in Canada, for Canadians, yes, I'm going to F you up is what that means. So in certain places, it absolutely is a threat. Is this more gaslighting? What are your thoughts here?
It's parsing out and trying to nitpick things. Again, the judge, when they're reading a complaint, is supposed to look at the full context of where they are. And when in a vacuum, it may not be a threat, right? If we're just looking at it in a vacuum. But again, the Baldoni complaint shows this threat was made, and then look what happened when I didn't do what this person wanted. Look what I had to do. I had to submit. I had to bend to her will. So you're supposed to read the complaint not in a vacuum and one thing at a time, but in the full context that it is given. And again, Baldoni's complaint is so thorough that the context can lead a reasonable fact finder, the jury, that the judge cares about. Can a jury see this as a threat that would lead to extortion? I believe the judge will go there. There's enough context and backstory in the complaint itself to show that threat can lead a jury to think, yeah, maybe she was trying to extort him.
Yeah, I mean, it's clear so all that story of stealing the movie, the edit, all that she was doing becomes relevant because when you had all that context, Justin's been playing along this whole time. Fine, let's just get the movie done. And then it's really like, well, now all goodwill is lost. The gloves will come off. How is that not a threat? It's clearly a threat.
Right. And that's part of I don't know if it was intentional by Friedman's team to put it all there to anticipate this fight. But now it's helping them that they were so thorough because the judge doesn't have to rely on declarations from somewhere else. It's just like, listen, this is the way it reads. You may not like it, Lively. I'm not going to kick it out now, but this is the way it reads.
Amazing. So another point I wanted to get through. So they bring up again another stunning example of Baldoni's faux feminism. He argues that his wife should be liable for her husband's statements. Fortunately, that is not the law today. And so they continue. Further, the fact fails to plausibly allege that Miss Lively played a responsible part in the production. In the publication. Another quote here: even if the Sloan parties, so Leslie Sloan also had statements, were defamatory, the FAC fails to establish that Miss Lively would be liable for them. And then yet another one, instead the FAC wrongly credits Miss Sloan as having devised and executed smear campaign on her own against Baldoni, which if true would mean she was not acting under Miss Lively's direction. The fact includes no facts to suggest that Miss Sloan was Miss Lively's employer. It alleges that she was only Miss Lively's publicist. So again, weird semantics they're trying to argue here, but how does Leslie's job factor into this, since she's hired to handle PR matters for Lively? Lively pays for her services. Does that not make her an employee of Blake Lively? What are your thoughts here?
So this is a good use of semantics. Again, when you're on the ropes, you try to do anything to try to highlight something that, if it's believed, can help your case, and you be not on the rope. So you don't need to be an employee of someone. So here, let me just use Lively can be liable for the acts of not only her employees, which is what they're trying to limit this in scope, but also Lively's agents, someone that she is connected to knowingly as part of her team and part of carrying out her business or enterprise. So an agent or a publicist would be an agent, an extension of Lively's enterprise. And as an agent to Lively, her conduct can be imputed to Lively. So it doesn't have to be an employee relationship in the traditional sense. And that's what they're trying to say. Like, she's not an employee. How can she be? She's an independent contractor. So then this legal principle, it was called respondent superior, which is a Latin way of saying the boss is responsible for the employee's conduct. Well, it's not just the boss and employee, it's the contractor and her agent. So when Sloan is an agent, which she is an agent from a legal standpoint, and that cannot be disputed. What she does can, by a fact finder later, not by the judge now, but by a fact finder later, show, oh yes, what Sloan was doing was part of Lively's enterprise and efforts professionally, and should be imputed, and Lively should be responsible for the agent's conduct. So again, this is trying to highlight something, but that's not the full story, and unfortunately, that's been Lively's strategy the whole time.
Amazing. This is so insightful. A couple more points I want to get through. So they talk here about Wayfarers still fail to plead the basic elements of extortion. And then they bring in this whole idea about this production letter, this PGA letter that they were forced to write. They were not literally forced to acquiesce this PGA letter, which they were writing. But the reality is, as we go through, I don't know where it went, the email that James sent, here it is. It's very hard to read, but I can quote it here. James very clearly writes, essentially the movie, It Ends With Us, has been taken unjustly from Justin as a director and essentially from Wayfarer's control due to the extortion of Blake. Justin and I ended up agreeing to write the letter due to feeling trapped. She continues to hold a threat over our heads every time we try and hold the line, and she uses that threat, either directly or indirectly, to fold. Blake argues that the Wayfarers' claims of false light, extortion, breach of contract, torturous interference before focusing on civil extortion. The filing claims that Wayfarer parties concede that Miss Lively did not acquire money or through her purported wrongful threats. To save face, they selectively quote Monarch's deposit versus Gilliam, incorrectly claim that acquiring property or money is not required to sustain a claim for civil extortion. So I now ask you, does money have to be acquired for civil extortion to be claimed? And is Jamie right to consider that the PGA mark that she demanded, that they then forced them to write that letter for, is that a tool that could have been used to extort and control Wayfarer?
So there's a lot of points here. To answer the last question, you don't need there to be a literal handing of money or handing of property for extortion claims. It could just be being coerced into doing something that will lead one person from losing money eventually and the other person from gaining money eventually, right? So it doesn't have to be gun to the head or holding someone's hand to sign a contract. It could just be coercion or duress. It doesn't have to be physical force, which is, again, how this reply is trying to be imply that no one went up to Baldoni and put a gun to his head and put that's not required. It just has to be duress that is reasonable under the circumstances. And again, how it's pled, because the judge has to assume everything in Baldoni's complaint is true as it's pled, as it's drafted, as the narrative is written out. It can be reasonably inferred that under those circumstances, there was duress and a sense of being coerced into allowing into writing the letter that ended up getting to the benefit of who? Of Lively, to the detriment of who? Baldoni. And that is enough now for purposes of asserting a claim of extortion.
So yes, Jamie's did feel extorted. It can be used that way.
Yeah, because extortion doesn't require, something you see in a mafia movie. It could just be like, I feel like if I don't do this, I'm going to be really screwed. So I have to acquiesce to this threat, to this duress in order to avoid something. And look, that ended up me losing something and her gaining something. That's enough.
So again, I have a couple more, but overall, you do feel like she is gaslighting. The legal gaslighting term is happening here. There's a lot of weird maneuvering here to try to just deflect from the reality.
Yes, we call it a lot of mental and legal gymnastics.
Mental and legal gymnastics. All right. One point here after can you understand what's actually being said here? And do you agree with her? After years of promoting themselves as supporters of women and victims of abuse, Baldoni, Sarowitz, Heath attack a California statute that was drafted specifically to protect victims from abusers who weaponize defamation law. Contrary to self-serving contention, Section 47.1 is not a procedural statute. It is substantive privilege against liability with a fee shifting and damages provision attached, both textbook examples of substantive California law that applies in federal diversity actions. Do you agree with this statement?
No, I don't. And there's a lot of distraction here. At the end of the day, 47.1 is, in my opinion, a good tool in order to punish people who try to silence victims of SH. She is, based on reading Baldoni's complaint and assuming it is true, there is evidence that she acted with malice and she did not have a reasonable basis for that. And that is what Baldoni, in his opposition, said very, very clearly. Friedman, right? She didn't have a reasonable basis and she had malice. It is not an absolute shield to just, because people do bring up BS. I'm sorry. Like, I'm a plaintiff's attorney. I just represented a victim of SH. But even I know sometimes people come over like, I don't think this is true, and I won't take those cases. But there are attorneys who will. And I do believe that there should not be that abuse either. That's why there's this qualifying language in the statute saying it's not just anybody. It's someone who didn't act with bias. It's someone who had a reasonable basis for belief. And again, the judge is going to read Baldoni's, the judge has to read Baldoni's complaint as if everything in it is true and go, you know what? I'm not saying it is or it isn't, but the jury can find that there's malice. And it's possible the jury can find that she didn't have a reasonable basis. And that is enough for this stage and this attack to be denied.
It's weird, yeah, because that law shouldn't just be there to be like, yeah, all women or anybody who comes forward and labels it, you can't defend yourself. It's like, and what she's doing feels like it's the opposite of helping victims. If anything, it's drawing a spotlight on that's going to do worse for victims. Because, just like Amber Heard, I hate to compare, but just like Amber Heard kind of did, right? She's just digging herself deeper and deeper. As an attorney, like, are you as shocked as a lot of us are that she keeps digging her heels into this, like, and playing that victim card as loudly as she is?
Well, I have two feelings. One, she has to do it in order to survive. She has to do this. This is her only chance in order for her to have any legitimacy in this forum of legal battle, right? From a policy standpoint, as someone who does do this for a living in California, it is something that we fear may bring so much bad attention that it may create what we call bad law. Bad facts creates a bad law. And either the Court of Appeal, the legislature might go like, you know what, this is being so abused that we may have to change it. And at the end of the day, we don't want that, because the purpose of this is good, but it is being abused. And now there's a huge national, maybe international spotlight on it. And it may lead to a consequence of eventually maybe taken away or diluted to help people that it really is supposed to help. And you don't want that.
So in conclusion, all claims against Miss Lively should be dismissed with prejudice and without leave to amend. The court should award all requested relief. Do you think she'll get that? What are your final thoughts on this entire piece?
I don't think so. I think just either by luck or by design, Baldoni's complaint is so thorough that I don't think a judge in good faith in their role as just what they're supposed to do, read that thing, assuming everything is true, and agree with Lively. I just don't see it happening.
And this, again, this is just drowning them out. This is her sort of attempt. I mean, there's a part of me that does feel like that might work, right? At this point, even though Baldoni's winning, I imagine in your place with victims you're with, they get exhausted, no? They just want it to be over. So is that actually maybe a viable thing of drown them? It doesn't matter if you're looking bad. Drown, because then we might get the settlement. Do you think there's maybe some mental gymnastics and things happening on Lively's side? That's why they're sort of doing this? And what would you advise to Justin, I guess? Stay the path, ignore, just do it all, take it all the way?
Right. So when you're dealing with people at this level and caliber of power, right? Ryan Reynolds is not someone who is a sheep. You know, he is at the apex of his celebrity and power, and he's married to Lively. When you have attorneys going, I can just drown them so that maybe they make a mistake, he probably can say, go ahead and do that. And from a business perspective, that is probably something you do in business. The problem is you have someone else who, one, is kind of winning the PR battle. Two, is getting support in that he's getting his own set of attorneys. And that attorney, Friedman, is probably motivated to probably work 100 to 200% to prevent whatever effect Lively's team is trying to have. So now, and then the problem is this: if this goes to a jury, it's going to be very, very hard for a jury to exist that hasn't heard this news, right? That's not supposed to know about this stuff. And that is going to be very, very, she's going to be on the back foot if it gets to a jury going like, well, you've been terrible this whole time. We've heard this news and you've tried to be this and pretend to be that. And like, you know, it's not a good look. So it is a very short term, in my opinion, Lively strategy is a very short term that I don't think will work, because Baldoni is not some you know, shrew. He may not be the most powerful man in the world, but he has a lot of backing and a very motivated, very talented attorney. And I think it's a short-term possible gain, but at the long run, it's going to bite them in the butt.
Amazing commentary, guys. Thank Ron so much in the comments. Please keep coming back. We love having you, especially in these Friday updates as these filings come in. Yep. Longer video, but I think worth it. So there you go. Some really insightful insight. And again, from an expert, mind you, who literally just schooled Soulja Boy. My goodness, kudos to you. Nice work what you're doing out there. I owe you a t-shirt because we just launched our shirt. Please let me know any item you want in this store. I will ship it to your size. But guys, the merch store just launched. Pick up your Popcorn Planet gear. So excited to have it all there. I hope you guys enjoy it. We got a lot more coming, including our investor pack and more. So stay tuned for those announcements, but check the pinned comment. Ron, always a pleasure. You're such an awesome expert on all this. Guys, make sure you subscribe here. Hit the bell for all alerts if you haven't already. Smash the thumbs up and leave your comments down below on what your thoughts are. We got a lot more coming to you. This case is clearly not ending with us. So we will keep you posted. Ron's in the documentary. We got a lot more coming. It's looking amazing. Stay tuned, guys. You're not going to miss it.